Imagine this. You win at business. You work hard, you build your wealth, then one day a lawsuit comes crashing into your life like a wrecking ball. You sit down with your lawyer, and instead of helping you put your money in a safe legal fortress, your lawyer says, don't bother with asset protection. Now, wait a minute. Don't bother? Isn't it their job to protect you? Why on earth would an attorney discourage you from protecting your life savings? Well, the answer has a lot less to do with you and a whole lot more to do with them. So stick around, because in this video, I'm going to break down the real reasons why some attorneys tell you not to protect your assets. Reason they don't exactly put on their business cards. And trust me, once you hear these reasons, you'll never look at that advice the same way again. By the way, I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. I've been in the asset protection field for 34 years, and nearly 30 of those I've been setting up Cook Islands trusts. More of them than any firm in the world. So yes, I've seen firsthand why some people's lawyers get squirmy about asset protection. So before we dive in, make sure that you hit that subscribe button right now if you haven't, so that you don't miss out on future videos that reveal the secrets of protecting your wealth. So let's jump right into it. Here's the first big reason. Asset protection makes many lawyers feel like they're not needed anymore. I mean, think about it. How do most attorneys make their money? It's by going to battle in court, filing motions, fighting creditors, appealing judgment. Every hour they spend fighting for you is another billable hour. That's their business model. Now, what happens if you have a rock-solid offshore trust in the Cook Islands? Now, suddenly, those creditors can't touch your money. Therefore, there's no incentive for them to drag you through endless discovery on trial prep. Your attorney can't bill 100 more hours defending it because the lawsuit loses its teeth almost immediately. Here's a real example. Years ago, a client of ours was sued for millions. He had already placed his assets safely in a Cook Islands trust we set up for him. When the opposing attorneys realized they couldn't penetrate the trust, the case fizzled. Why? Because creditors don't like spending years and hundreds of thousands of dollars chasing money they can't collect. Now, if that client had relied only on his trial attorney, guess what would have happened? Years of courtroom battles, endless hearings, and mountains of legal bills. Instead, the trust ended the fight before it ever began. So when some lawyers say, don't bother with asset protection, what they really mean is, if you protect your assets, I can't bill you as much. Now, it's harsh, but let's be honest. The legal profession is a business. Another reason is all about reputation. Attorneys live in the courtroom world. They appear before the same judges again and again, and reputation is currency. If a lawyer knows Judge Smith hates asset protection trusts because they make it harder to enforce judgments, that lawyer is going to think twice. Why? Because they anger that judge today, and they'll have harder times winning cases tomorrow. But let me ask you this. Is it your job to protect your lawyer's reputation, or is it your lawyer's job to protect your money? Here's the cliffhanger. Later in this video, I'm going to tell you all about a real case where a judge went on a tirade against asset protection and what happened to the client. Spoiler, it wasn't the disaster the attorney feared. So keep watching for that. Now, this is closely related, but it's worth separating. Some judges don't just dislike asset protection, they hate it. They see it as a direct challenge to their authority. And when a judge gets offended, they can make life miserable for everyone in the courtroom. And lawyers know this. So to avoid triggering a judge's wrath, some attorneys steer their clients away from asset protection altogether. They think, better safe than sorry, let's just keep the judge happy. But here's the reality. An offshore asset protection trust is built to withstand even the angriest judges. Yes, the judge might threaten, they might scowl, they might try to throw the book at you. But ultimately, U.S. courts can't force a foreign trustee company in the Cook Islands to obey. Now, we respect judges, don't get me wrong. So we're just stating facts here, because it's like a judge shouting orders at somebody outside their jurisdiction. It makes noise, but it doesn't change the law, and that's why our clients sleep soundly even when a judge pounds the gavel in frustration. Now, here's the big one. Most lawyers simply don't understand asset protection. It's not taught in law school. In fact, when our firm started hiring lawyers years ago, I was shocked at how little the new attorneys that I hired understood about asset protection. I had to train them from ground up like I do today. It's not taught in law school. Seriously, ask any recent law graduate about Cook Islands trusts, Nevis LLCs, or equity stripping strategies, and you'll get a blank stare. Law schools teach how to fight cases, not how to prevent them. So when a lawyer hears about offshore trusts that blocked creditors, it sounds too good to be true. And let's face it, lawyers are trained to be skeptical. If they don't understand it, they'll assume it's risky. And I can't tell you how many times I've had attorneys message me and say, "Hey, business guy, my client is interested in asset protection, but I'm worried it's illegal." And I'll walk them right through the statutes, the case law, the real world enforcement or lack thereof in places like the Cook Islands. By the end, their jaw drops, and the truth is, asset protection isn't illegal at all. It's just outside the comfort zone of most attorneys, and when somebody doesn't understand something, the easiest response is to dismiss it. Now, finally, there's the issue of fraudulent transfer. Now, this is a civil claim that says you moved assets just to keep them away from creditors. Many attorneys wave this around like a boogeyman. They'll say, "Don't set up asset protection. It could be seen as a fraudulent transfer." But here's what they often forget. Fraudulent transfer is generally not a criminal offense. We've never seen any of our clients go to jail for it. At worst, a judge might try to undo the transfer. And even then, if your assets are in a Cook Islands trust, the foreign courts don't enforce U.S. fraudulent transfer rulings. So let's put this in perspective. Imagine you move assets into a trust after being sued. There are three possible outcomes. Number one, the U.S. court rules at a fraudulent transfer and orders you to hand over the assets, but the offshore trustee in the Cook Islands says, "Sorry, we don't recognize that order. Your assets stay safe." Number two, the court rules it is not a fraudulent transfer. Great, your assets are safe. And three, the court doesn't bother challenging it at all. So really, there's one potentially bad outcome and two good ones. And if you have your assets in a Cook Islands trust, the bad ones don't really matter. So compare that to doing nothing, where you're guaranteed to lose the assets if you lose the lawsuit. So that's why I say fraudulent transfer claims are not a reason to avoid asset protection. It's actually a reason to do it sooner rather than later, before a lawsuit even exists. Case study cliffhanger resolved. Okay, now as promised, case study cliffhanger resolved. The judge who hated trust. Remember earlier when I promised to tell you about a judge who hated asset protection? Well, here's what happened. A client of ours had assets in a Cook Islands trust. The U.S. judge was furious. He actually said in open court, "I don't like these offshore trusts because they make it hard for me to enforce my orders." But here's the kicker. His personal feelings didn't matter. The trust was in a jurisdiction outside of his reach. The judge could rant all day, but the client's money was untouchable. That client later told me that was the best investment he had ever made. While the judge was angry, I was safe. And that's the real lesson. Respect the judge, but don't let fear of a judge's reaction or attorney's discomfort stop you from protecting yourself. Okay, so what's the strategy that solves all these issues? It's a structure we use constantly. A Cook Islands trust with a Cook Islands LLC inside of it. And here's how it works. You're the manager of the LLC while the waters are calm. You still call the shot. But if a lawsuit strikes, our licensed bonded trustee company law firm steps in, they follow the trust instructions, and because they're offshore, they don't have to follow U.S. court orders. This way, you keep control when times are good, and you gain protection when times are bad. The best of both worlds, flexibility and ironclad security. And by the way, at Asset Protection Planners, we've set up more Cook Islands trusts than any firm in the world. We've seen every scenario you can imagine, and we know how to build these structures to withstand attacks. So now let's bring this full circle. Why do attorneys tell you not to protect your asset? One, because it cuts into their billable hours. Two, because they worry about judges more than they worry about clients. Next, because they fear retaliation in court, because they don't understand asset protection. And finally, because they overestimate the danger of fraudulent transfer, but none of those reasons are your reason. Your reason is simple. You worked hard for your money and you want to keep it. Okay, I'll leave you with a quick story. A business owner that I know ignored asset protection because his attorney talked him out of it. He said, "Just buy more insurance." Well, when the lawsuit came, the insurance company found an exclusion and walked away. He lost millions. And later, he told one of our employees, Paul, I wish I'd called you sooner. So here's a closing invitation. Don't let somebody else's fears or their billable hours dictate your financial safety. Protect yourself. If you're serious about defending your wealth, you can feel free to visit us at assetprotectionplanners.com to get a whole lot of free information there. And if you have over $500,000 to protect and you're serious and not just curious, schedule a free consultation online. My team and I will walk you through the right structure for your particular situation. And before you click away, remember to subscribe to this channel if you haven't. We release videos every week that reveal exactly how the wealthy stay wealthy and how you can too. Because at the end of the day, attorneys may not want you to protect your assets, but when that lawsuit hits, you'll be glad you did.